Hi, I'm Dr. Sam King, Medicolegal consultant with Medical Protection. Today we're talking about the Office of the Privacy Commissioner and when money might change hands. Joining me today is Dr. Tim Cookson, fellow medico-legal consultant, and Mr. Adam Holloway, who's a partner at Wotton Kearney, one of our panel lawyers. Thanks, guys, for joining me.
Hi, Sam.
Thanks, Sam.
As many of you are aware, privacy is a minefield and not necessarily easy to get your head around. And when a privacy complaint is made by a patient, there are a number of possible outcomes. And to illustrate this process, let's start with a case. Now, this case is made up of a number of different cases that I've had in the past, just to let you know that this is not a specific case as such. So this case is relating to Dr. Strange. And he is a GP. He is working as a short-term locum when an ACC request for notes came in. Mrs. Bush had a history of mental health problems and ongoing problems from a back injury. ACC requested all clinical notes pertaining to the back injury and wanted to include reference to pain and depression dating back to 2015. This was to include all specialist reports, correspondence, results of investigations performed, and there was a signed consent form. Dr. Strange read the request and sent ACC a copy of all notes dating back to 2015, so it wasn't just pertaining to the injury and depression. His reasoning was that it was too time-consuming to sift through the clinical notes, especially since many of the consultations relating to the ACC matter also included the list of other problems the patient was seen for in that same consultation. One of the problems that Mrs. Bush came to the clinic for on multiple occasions included a history of previous sexual abuse, an intensely private matter to Mrs. Bush. This was entirely unrelated to this ACC claim, and these notes were inadvertently released to ACC. Compounding the problem, ACC then passed the clinical notes as sent by Dr. Strange to other parties. When Mrs. Bush found out that this had happened, she felt very traumatised by the disclosure to the point where her daughter claimed she considered suicide. The daughter wrote a letter of complaint initially to the practice, clearly indicating that they wanted an explanation and apology, but also financial compensation for the hurt and humiliation caused by the disclosure. Tim, what would you advise the practice to do upon receiving this complaint?
Well, firstly, to take this very seriously, because these are the kind of problems where usually in New Zealand, where the clinical issues, money doesn't change hands, but privacy can be different. And so the practice needs to be immediately exceedingly careful. My first comment would be to contact MPS, because this is what we do to assist. And we would always get a lawyer involved right from the beginning with this kind of thing. However, immediately, one of the first things the practice needs to do when they become aware of a privacy breach is to see if there's any containment that needs to be done. Now, in this particular situation, it's not really that kind of case, though they might think about writing to ACC and say, please don't send a copy of these notes to anybody else. Limit the potential damage. And then the practice has to look at what's happened. So clearly they need to speak to the doctor involved, find out why he did what he did. And look, I've got to say, I do empathise with his thoughts that it's just too difficult to try and separate out these matters. It's sometimes really difficult, and I've had to sometimes with paper notes, where the case has gone back a long way, you've got to photocopy the paper notes and then twink out the bits that don't apply. It is very tedious, and you really do think you've got better things to do with your time. So I can totally understand why Dr. Strange would have done what he had done, even though it was the wrong thing to do. The practice will obviously need to provide a written response eventually, and so to do that, they've got to have a full investigation. Look, there needs to be an apology in that because clearly the doctor did not follow the rules, and apologising for that is appropriate. And ideally, too, the practice should, as part of that investigation, have worked out ways that it can prevent that kind of thing from happening again. So it might be that for all locums, as part of their orientation, there's a bit on, the importance of, with ACC requests, only releasing information that is relevant to the injury and the inquiry. And then finally, they've got to think about whether it meets the threshold for notification to the Office of the Privacy Commissioner. So there's quite a lot to do.
That's right. And for the notification process, the Privacy Commissioner's website has a Notify Us tool, haven't they? And so as you walk through that, it'll give you a clear indication of whether or not you do need to notify the Privacy Commissioner.
Exactly, and also on the Commissioner's website is actually a clear guidance as to how to manage a privacy breach as well. So all that information is there, and I would suggest every practice who does receive a complaint, they look at that as well to make sure they're not missing any of those important steps.
And I would emphasise Tim's advice that it is a good idea when you get a serious communication like that, drawing your attention to a breach and also indicating that some compensation is going to be sought, to put a call through and get some assistance. So there are better ways than others in terms of how to respond to that sort of letter to try and avoid an escalation of the person's concerns. And as Tim and Sam, you've just mentioned, we're still reasonably recently into this regime, but there is now, in certain circumstances, an obligation to notify privacy breaches to the Privacy Commissioner's office. So not every breach will require you to make a formal notification. And there's a set of statutory criteria you have to work through. But even then, the answer is not always 100% clear, and it may well be quite a comfort to people who are having to make that call. Is this something I need to notify or not? To reach out and get some assistance, and then you can move forward knowing, okay, well, look, I've done the right thing by notifying the Office of the Privacy Commissioner. Probably at this early stage, the Commissioner's office isn't going to get then immediately involved because it's quite a small scale breach only involving one individual. But you will have ticked that box, and you can then focus with assistance on trying to manage your way through to a resolution of this person's grievance.
And as you say, Adam, this requirement to report certain breaches to the Commissioner is new. That wasn't part of the law previously. And in the early stages, the Commissioner's approach was to take an educative approach. So, for example, a breach which should have been reported but was not, and then eventually comes to the attention of the Commissioner, they were going to write back and say, look, tut, you really should have done better. Excuse me. But now that's changed, and the Commissioner said, this has been in place long enough. If you do not follow the rules, then there will be penalties that will be applied.
So the daughter has asked for some compensation. Adam, what would your advice be to the practice at this stage regarding that, compensation at the initial stages?
So at this early stage, my advice would be to make sure that the person feels like the concern they've raised has been acknowledged. So to communicate back and say, look, thank you for getting in touch. You've raised a really important issue, and if this has happened, then that's not great. But the first step we need to do is to investigate at our end, and you deserve us doing that process to figure out what's happened from our perspective. So if you can allow us the time to do that, that would be appreciated. So some version of that to try and keep the complainant on board and not then going to precipitously make a complaint to the Privacy Commissioner or do something ahead of you coming to grips with what's happened and understanding, perhaps with some legal assistance, what your exposure is. Because if you can get your head around that before you then engage in a more substantive way with what you might be prepared to do to settle the matter.
So in the initial stages, you shouldn't talk compensation. That's the bottom line of what you're saying?
I would say it's too early to do that. The person's obviously seeking that, but until you've understood what's happened and had the opportunity to get some advice, then it would be ill-advised to immediately jump to a conversation about, I see you want some compensation, let's talk numbers.
Yeah, no, that's good. So at that point, Dr. Strange and the practice contacted Medical Protection, and he was clear that a privacy breach had in fact occurred and that he was at fault. However, it was uncertain how much information was disclosed outside of the consent, as the practice didn't retain a copy of what was sent to ACC. We advised him to draft a response explaining how the error happened, what changes the practice were making to their processes to avoid this happening again, and to make a sincere apology for the error, but no mention was made in that letter regarding compensation. Mrs. Bush and her daughter weren't happy with the response and so complained to the Office of the Privacy Commissioner. The Privacy Commissioner's office advised Mrs. Bush to go back to the clinic, and if a resolution couldn't be reached, then they would become involved. So this time Mrs. Bush wrote another letter to the practice via her lawyer this time, where she pushed for compensation for ongoing treatment costs as a result of what she considered to be an injury. And she also claimed for lost wages, and all of this amounted to around $60,000. Clearly, MPS involved one of our legal team. And so through our lawyer, we wrote back and advised that in order to assess the claim, we needed to know what information ACC received in error. And because we couldn't settle on that, we couldn't find, we weren't able to receive any information regarding what information was in fact released. It tended to stymie the process, and ultimately the Privacy Commissioner closed the file because it simply couldn't proceed. So in that case where there's really no outcome and the Privacy Commissioner has closed the file, Adam, what options would be open to Mrs. Bush at that point?
So it's a slightly unusual situation, isn't it, where the complainant has alleged something to have occurred, but has then withheld her consent to the relevant parties that would enable them to figure out what in fact actually happened. So I think in that case it was clear that information beyond what was necessary had been given to ACC, but precisely what was the content of the extra information wasn't clear, and without Mrs. Bush's permission, that couldn't be ascertained. And unsurprisingly, the Privacy Commissioner just wasn't able to reach a view on the nature of the breach without that information. What that means, though, is it's not the end of the matter. So having decided not to conclude an investigation, the ball goes back into Mrs. Bush's court, and she can then decide to issue proceedings in the Human Rights Review Tribunal alleging a privacy breach. It's a more difficult process than making a complaint to the Privacy Commissioner. It would be difficult for her to do that without the assistance of lawyers. Not impossible, but difficult. And the tribunal process is incredibly slow. So while she may well establish at the end of the day that there's been a breach, it's a very long road to get there. So that was one of her options at that stage, would be to go and file a claim. The other option would be, of course, to provide the missing information, and that probably the Privacy Commissioner would have picked things back up, or to continue to engage with the practice to endeavour to reach a private settlement in relation to what had occurred. So from her perspective, I think those were the options. In terms of the practice, either to engage in private settlement discussions to try and make this go away and It may well have been a case where it was taking up significant organisational time. If there was a lot of communications from Mrs. Bush and she was continually contacting the practice about her worries, or they could have called her bluff and said, well, you haven't provided the information. We can't take this any further. Sue us if you want. So that's an option, and it's an option to take that hard view. The risk is that a claim does materialise, and even if it's not a strong claim or it's one that's being prosecuted without the assistance of lawyers, it will still take more time. From a member's perspective, even if they're not paying the bills of the lawyers who are helping them because MPS is sorting that out, they're still going to have to engage with the process, be contacted by lawyers for information, write witness briefs, etc. So it may well be that if a settlement can be reached at an appropriately modest sum, it's still a better call to solve the problem that way.
And certainly MPS has had experience of some of these cases going on for ages and ages and ages. And for a while, 8 years was the longest that we'd had, but then that got supplanted by one that took 12 years before it finally got resolved. So, yeah, paying money sometimes is better than having things drag on and drag on.
That's right. And so in this particular case, negotiations began and a settlement was reached. And because of Mrs. Bush's refusal to divulge any information, the sum was eventually settled for much lower than was originally asked for. But it's interesting that often in privacy cases, it's not uncommon, unfortunately, for money to change hands. Adam, in your experience, where there is a privacy complaint and a significant breach has occurred, what is the Privacy Commissioner's approach? And I understand that we've got a new commissioner now, but in general, what would you say is the Privacy Commissioner's approach?
Yeah, so the general way these things unfold is a complaint will come into the Privacy Commissioner, and if it's pretty black and white, so there's not a lot of room for argument about the fact that a breach has occurred, you can expect the Privacy Commissioner very early on in the process, and sometimes even before there's been an investigation, to invite the parties to facilitated settlement. So, like many areas of government, the Privacy Commissioner, I'm sure, is struggling with volumes of complaints versus resource to deal with them all. And that might be one of the things driving trying to get an early solution. But actually, an early solution is good anyway. There is no need to put effort into investigating something where the facts aren't really in debate. Better, I think, for the Privacy Commissioner to use their expertise and resource to try and bring the parties together and resolve the problem. So the first thing you can expect is an early approach from the Privacy Commissioner's office to see whether or not this is a problem that can be solved ahead of an investigation. If it can't, then an investigation will occur. The Privacy Commissioner isn't compelled to formally investigate every complaint, but in the scenario we're dealing with where it is a significant error, then you could expect an investigation to follow with a conclusion that the complaint is determined to have substance, I think is the terminology used in the Act. And again, at that point, there will be a further effort from the Privacy Commissioner in light of the determination that the breach has occurred, which carries some formal weight, to see if a settlement can be reached. And that may involve bringing the parties together to try and crack that nut with them both either in the room or both on a call. If settlement fails again at that stage, then in some cases, but in these are the rarer cases, the Privacy Commissioner might decide to then prosecute that breach themselves before the Human Rights Review Tribunal. But much, much more commonly, the problem will be handed back to the complainant, and they will have the opportunity to file their own claim before the Human Rights Review Tribunal. But they'll file that knowing that at least one official body has upheld their complaint, so they can go into that process knowing that they've got a pretty good prospect of success. And anyone failing to settle in a having been found by the Privacy Commissioner to have the breach upheld would be well advised to continue to try and see if this is a problem that can be solved by settlement ahead of a full Human Rights Review Tribunal case. Now, sometimes complainants just have unrealistic expectations, and that's a shame when it happens, but it does mean that not every case is capable of settlement. But once you move into the tribunal process, you can make formal offers in a certain kind of special way which will protect you from some of the lawyer's costs of moving through the process if a reasonable offer has been refused ahead of a hearing.
Thanks, Adam. It's all very much at the serious end of privacy breaches. Fortunately, compared to the number of complaints that are made, I think relatively few, in fact, are referred by the Privacy Commissioner's office for proceedings in the Human Rights Review Tribunal. I think in the 2020 annual report, there were only 3 complaints that they referred to the Director of Proceedings for consideration of proceedings. But there were quite a few more, 23 complainants took proceedings in the Human Rights Review Tribunal themselves. And of course, there were a number of settlements outside of that as well. Let's go back and just talk about what you do when you discover a privacy breach. So let's just say it wasn't the patient is unaware that there has been a breach, but you work in a practice or at the DHB and you've discovered that there's been a privacy breach. Tim, would you mind just talk us through the steps that clinicians ought to take?
Yeah, look, we probably sort of covered some of those earlier on, but it's good to repeat them. So, look, first of all, as we mentioned, there's clear guidance on the Privacy Commissioner's website as to the process that needs to be followed. And so it's good to review that, but it's also good to get in contact with MPS at that very early stage as well, because privacy often has legs, and getting in early is the way to go. First thing to do is to try and contain it. So if, for example, an email has gone out that had information that should not have been supplied, contact those people who have received the email, ask them to delete the email, and obviously not to disseminate any of the information that might be on it. And if it's only gone to 2 or 3 people and you've contacted them all and they all say, yep, sure, I'll do that, and you can be reasonably reassured that they have done that, then that's immediately diminished the impact of the breach, because a breach, of course, has got 2 parts. It's the breach itself, but then it's also the potential harm that breach has caused, and both of those need to be considered in the whole context. Once you've done that immediate action of containing, then you get on to that process of having a look at what happened. So was it that your staff haven't been instructed to use the BCC rather than the CC part of the email when they're sending out lots of information to a group of people? Have they just not received adequate training? And in a situation like that, if the training has been inadequate, then obviously the practice itself is going to be more vulnerable than if it's an individual error despite really good training. So assess what happened. If something has occurred but the individual whose privacy has been breached isn't aware of it, then you need to consider whether they need to be informed. And that's not entirely straightforward. We had a case where a GP practice was transferring notes of an elderly patient to another practice. A lot of them were paper notes, and there were misfiled documents from 4 other patients in that file that went. And when we asked them the question, do you think these people should be advised? In the end, they came to the conclusion that 2 of them, yes, ought to be advised because the information that was contained wasn't that personal, and therefore the shock to them of knowing that someone else had read their information was likely to be too big. but there were two of the patients, unfortunately, who had significant anxiety and other mental health issues, and the practice made the decision, having thought about it very carefully, that actually the knowledge that their information had been breached might have caused them more harm than the actual breach did. And so there's quite a complicated process that needs to be gone through. And again, we're really happy to assist with that process of thinking about it. But ultimately, that decision would need to be made by the practice, because they're the only people who can really know what the impacts might be. And it's important also to document all of those things as well, because when it gets to the Privacy Commissioner, if it goes there, the Commissioner is very keen to know the processes that you've been through and the thinking that's been applied to your decisions. And sometimes you can make a wrong decision, but you've gone through the right process, and the Commissioner will look much more favourably at that than they would if there's just a complete blank as to why you might have done something. So you need to consider whether to tell the people whose privacy has been breached, and then you need to look at your policies and do any upskilling of staff, etc., etc. And then, of course, there's the big thing. Do you notify the Commissioner that the breach has occurred, given the new regulations? And maybe Adam could tell us a bit more about the specific things that might lead you to notify the Commissioner or not notify the Commissioner of a breach.
Absolutely. So, it's a real lawyer's answer, unfortunately. So, what the Act says is that a notifiable privacy breach means a privacy breach that it is reasonable to believe has caused serious harm to an affected individual or individuals, or is likely to do so. Now, one might say, how is that an answer? It's more of a question than an answer. How do I figure that out? And that's the reason why people do seek assistance to answer that question. And in fact, the Office of the Privacy Commissioner provides assistance as well. What the legislation says is that it sets out factors that must be considered when assessing whether a privacy breach is one that is likely to cause serious harm. And those factors are whether any action taken by the practice in this case has been made to reduce the risk of harm, whether the personal information is sensitive in nature, the nature of the harm that may be caused to the affected individual, whether the person has obtained personal information as a result of the breach, and whether the personal information is protected by a security measure. So there's a smorgasbord of factors, essentially, that the law says when you're trying to make that judgment call around serious harm, please consider these things. And that moves you closer to the answer, but it still doesn't give you a black and white answer. These are not tick boxes. These are trying to make one judgment call by turning your mind to a series of other judgment calls. And what we find is that people who work in this area, who are having regular conversations with the Office of the Privacy Commissioner about should I notify this or not, will become familiar about how the Office expects those judgment calls to be made and what the Office thinks is important or less important. So what might seem understandably impenetrable for someone who's dealing with this for the very first time may well be much more straightforward for a lawyer who works in this area and is used to having those conversations and has a really good feel for what the Privacy Commissioner really is getting at in terms of cases where it is, I think as you said, Tim, there are cases where it's really important from an oversight perspective for the Privacy Commissioner to know that this problem is out there, and it's something which could result in real, genuine harm to someone. And that doesn't necessarily mean it isn't a problem that can't be solved by the practice. Recalling notes, going to the other GP practice and making sure that, the inadvertently passed on notes are retracted and destroyed. But there's still a lot at stake. And it is, as we've discussed, a reasonably new process, but I think on balance a good process for the state to have a better view about what's going on out there in the privacy space rather than simply relying on people to do the right thing in every case.
And there's probably no real harm in talking with the Privacy Commissioner if in doubt, is there?
Not at all.
And that's something that actually we often will do, well, you will do as a lawyer on behalf of a member. Will be say, look, I'm not going to give you any names at the moment, but I'm just going to run the scenario past you, and is this something that you want to know about or not?
Yep.
And get an answer accordingly. Yep.
I think all the things that you've just explained really does underscore the fact that privacy is a minefield. And I think so the learning points, if anything, from today's podcasts would be, firstly, ensure that the information you release has been consented to. Take your time. You don't have to release information as soon as the request has come in. And I know that in particular, some family members or even the patients themselves will demand, you must send this now, or I must have this now. But once the information's been released, it's very hard to pull it back. So take your time. You do have 20 working days in general to make your decision in the if it's a non-urgent request. So take that time if you need it. And call your indemnifier if you're unsure whether to release. And we get calls all the time about privacy, about whether to release, how much to release, who to release to. And so please make use of your indemnifier. Unlike other complaints, settlement is often the way privacy breaches are resolved. And so that's something to bear in mind. Know the steps to take when a privacy breach happens and consider your obligations to notify. If you have a look on the Privacy Commissioner's website, they do have some really good teaching tools on their e-learning platform. So make the most of that, and you can ask your staff to do those online courses as well to upskill. And MPS, I know that we do have in our archives some material on privacy and what to do. So please make the most of those things. So thanks, Tim, and thanks, Adam, for joining me today. And thank you for listening to this podcast. I hope it's been helpful, and we look forward to catching up with you on our next podcast. If you like the Medical Protection Podcast, please subscribe and leave a review. We'll see you again soon.